My name is Joe Adams. I'm an immigration lawyer and advocate based here in Los Angeles. We've got a few topics that I wanted to make sure to cover today. And of course, I'm really here to solicit your questions and respond to the topics that you want to talk about. Immigration is a very complicated topic in any time during a political season as charged as this one is. I was just watching or listening to the oral arguments at the Supreme Court this morning about whether or not Trump can appear on the ballot. In a politically charged atmosphere such as this, so much disinformation is out there in the public, and I think it's part of my job as an immigration advocate, as an immigration lawyer, to share the best information I can so that people can make informed decisions about their immigration journeys. The big news that I really wanted to talk about was this fee increase. USCIS has, they say, not raised their fees for the most part since about 2016. Well, of course, things were a lot different back then. There's been inflation. And so there's been a massive undertaking to raise the fees. There was what's called a notice of proposed rulemaking way back about a year ago, about this time last year. And there was a massive response from the government, from the public, from nonprofit groups, from immigration advocates, from immigration lawyers, really criticizing the government's fee rule. The big change that I see is as follows, and this might get a little technical, and if I go too fast, just raise your hand and slow me down. Historically, when a person goes for adjustment of status, for themselves, for their spouse, for their children, when a person adjusts their status from whatever status they're in, like an O1 visa or an E2 visa, into a green card, we always apply for a temporary work and travel permit. Historically, the government hasn't charged anything extra for that temporary work and travel permit. The idea was, well, the government might take many months to review the adjustment of status. There might be a big backlog. So as a stopgap, the government offered a temporary work and travel permit, an EAD, employment authorization document in immigration parlance, and historically never charged anything for that. Well, in my mind, the big thing that's come out of this new fee rule is they're going to be charging us now for the employment authorization document and the travel permit. This is sometimes called like thought of as a mini green card. It's a red colored card that for a lot of people serves as a temporary green card while the green card is being processed and finalized. Unfortunately, that is going to be a big financial burden, especially to families. You know, I have a family right now adjusting status, mom, dad, 2 children, and the filing fees alone end up being thousands of dollars. I think theirs was about $5,000 US just in filing fees. So to add this extra burden is, in my mind, it's pretty unfair. I'm going to record some content later for the web and for social media talking about my own immigrant ancestors, and they were not wealthy people. They had come from many of them had come from very poor parts of Europe. One in particular had come from a very poor part of what was then the Austro-Hungarian Empire, made very little money in his life, and was my great grandfather. And if he had not been able to come to the United States and raise a family here, I wouldn't be sitting here today. So it really hurts immigrants when we see fees like this. What I'll do is I'll put a summary of the fee rules into the chat. Let me see if I can do that. Where's the chat? Here's the chat. So as you can see in the link there, and I'll provide a link in the email that will follow this afternoon. You could have a look for yourself to see what all the fee increases are. The ones that really stand out to me, and let me share my screen. The ones that really stand out to me are that adjustment of status extra fee that we're going to be paying for what's called the Form I-131. As you can see, all these different form types. Oh, one note of caution when it comes to reading this chart. Okay, so again, immigration, I really don't like how jargony they can be. So they list out all the form types that they're talking about here, type of filing, what the current fee is, what the new fee is going to be effective April 1st, and then what is an NPRM fee? That's a notice of proposed rulemaking fee. So like I said, when the government originally proposed changing the fees, they issued a notice of proposed rulemaking. And I think what they're trying to do here is do a little bit of public relations to say, hey, we had talked about, let me find an example. Here's the I-129 H-1B fee. Well, it's $460 currently. We talked about raising it to $780, and we kept it at $780. We didn't go further than that. But say for the H-1B small employers and nonprofits fee, we talked about raising it to $780, but we ended up keeping it at $460. So I think that's what's going on here, is a little bit of PR on behalf of the Immigration Service. Just ignore this NPRM fee. That was what they had proposed. The final fees are what we're going to have to pay starting April 1st and going forward for most fee types. The other fee increase, and I don't know why they separated these things out, is what's called the I-907 fee, the premium processing fee. As you might know, there are fees we can pay in certain cases to force the Immigration Service to expedite the handling of a case. These are not available in family-based immigration cases, but in many of my employment-based immigration cases, O-1 visas, EB-1 green cards, there's an option to pay an extra fee for some of the process to get a faster decision. It shortens the processing time typically down from months to 15 days. And as it indicates right here, the current premium processing fee for different form types ranges from $1,500 to $2,500. For my O-1 clients and EB-1 clients, $2,500 has been the additional fee that you pay for premium processing. As of February 26th, not April 1st, but as of the 26th, that fee is going to increase to $2,805. And that's over and above what you're already paying. So remember, in order to get premium processing in a case, you have to pay not only the standard processing fee, so say in an O-1 case, $460, but you have to pay the extra premium processing fee as well. Right now, $2,500, and soon to be $2,805. And what that gets you, what that premium processing fee gets you, is a guarantee that USCIS will respond within a particular time frame. For most of my cases, that's 15 days. Right now, as I've harped on many times, if you've ever joined me in any of my prior webinars or chatted with me one-on-one or chatted on social media, I really rail against this idea that the Immigration Service can take a fee and then just sit on a case. It really aggravates me that the rules seem to provide this open-ended license to USCIS to take whatever the fee it is that they're charging, sit on the case for months or sometimes years, do nothing, provide no update, and then when they get to you, they get to you. But premium processing is the way to force their hand on that by paying money. Recently, I've been chatting with more and more people facing these unconscionable delays, and sort of the nuclear option when premium processing either isn't available, like in a family immigration case, or when the Immigration Service has made a bad decision, an incorrect decision, we're suing the government. And in fact, I've got 2 cases on deck that we're probably going to be filing in the next few weeks, one on delay, one on for a really stupid denial decision. So that's something that we could talk about as well if you have questions about what does it take to sue the government in federal court and get a federal judge appointed by the President of the United States involved in the case, and what does that mean in terms of outcomes. But it's something that we've had to do increasingly in the past, really since the Trump era. So really in the last 4 or 5 years, 6 years. I see people joining a little bit late. Rest assured, I'll send a recording of this to anyone who's interested and who signed up. If you have a question, just raise your hand or put it in the Q&A box on the lower portion of your screen, and I'll get to everyone's questions. The other thing that I wanted to chat about, we're celebrating Lunar New Year this year. I have a lot of clients who are from China, from South Asia. I wanted to sort of mark that and celebrate their holiday and to provide a sort of a welcoming environment. I also wanted to address some of the challenges that face immigrants coming from China, India, and from other parts of the world. What some of you are already familiar with is a document that is very confusing, and there's a lot of myths around, or people have not even heard about it. And this document I'm referring to is called the Visa Bulletin. Francesca, I know you know about this because we've been through this process, and you have your green card in hand now, so you were successful here. But the Visa Bulletin is a critical document that is very poorly constructed, and it's very confusingly talked about in the sort of the online community that are focused on immigration. Let me share it with you. I know it might be small type if you're on a phone, but I think it's important to see the document yourself so you can understand what I'm talking about. Okay. So the Visa Bulletin, first thing that I hate about this is that they call it the Visa Bulletin. The Visa Bulletin is about green cards. It's about permanent residency in the United States. Sometimes people refer to that as immigrant visas, as opposed to, say, non-immigrant visas, temporary visas that have a fixed end date. This is about permanent residency in the United States. I wish they would use a clearer term that was more accessible. So that's my first objection, just to the document itself. But the other thing to notice, February 2024, this is a document that's updated every month. We're here in the early part of February. I would expect perhaps next week, the US State Department, as part of its monthly obligation, will release the March 2024 Visa Bulletin. The Visa Bulletin, I'll put a link in the chat. Ooh, I probably shouldn't have clicked that. It's taking a second. But what I was trying to get is the overview document. I'll just cancel that. Let's see. Oh, there we go. Okay, so here's the link if you are interested. I'll put it in the chat to the Visa Bulletin. Whatever the current version is, but this is the version for February of 2024. Why is this important? Okay, so there's family-based immigration and there's employment-based immigration. Everyone seems to know that marriage to a US citizen, and sometimes people's parents, sometimes people's brothers and sisters, can immigrate to the United States based on their family relationships. So let me use a really simple and very stark example of how this document actually works in real life. Say, for instance, you are the brother or sister of a US citizen. Maybe you had a sister who came to the United States as a student, fell in love with her fellow student who is a US citizen, applied for a green card based on their marriage, and then applied for citizenship a few years later. So you are say an Indian national, a Mexican national, a British national, a Chinese national, and you have a US citizen brother or sister. You're able to go through the immigration process if your family member sponsors you. So that U.S. citizen sister could sponsor you under this F4 category. We have a limited number of green cards that can be issued per year. They're doled out based on preference level and based on country historic immigration patterns. So that we got these different factors at play. And every month, the State Department updates this document based on the prior month's immigration patterns and the usage of the green cards that are available. So let's use this F4 category as an example. Say, for instance, your U.S. citizen sister files the first document to get the process moving. That's what's called an I-130. Not a controversial document, not a difficult presentation. You show that the sponsoring family member is a U.S. citizen. You show that she is the sister to a foreign national with identity documents, and then it goes to USCIS. They approve it, and then the waiting game starts. There's a critical term here that we call the priority date. The priority date is your place in line on the visa bulletin, and your priority date is determined by the date that your, in this case, your relative files, not gets approved, but files the initiating document, in this case, an I-130. So say your sister files your I-130 today on February 8th, 2024, that becomes your priority date. Now, we look down here to the second section. This is what's updated every month. In the F4 category, there are not immediately available dates. And in fact, for none of the family preference categories, there are immediately available dates to go through the next step of the process. So if the person's in the United States in, say, H-1B status or O-1 status, they need to be very careful to maintain their status, or they need to depart the United States. Look here, if a person's sister, U.S. citizen sister, filed their I-130 way back in May of 2007, for most countries, only now can that person go through the next step, either adjustment of status or consular processing. It gets even worse if people are from India, Mexico, or the Philippines. It's even more retrogressed. That's the term we use. It's retrogressed. So, you know, why are China, India, Mexico, and the Philippines sectioned out? Because there's been higher interest in immigration from people from those countries than everyone else. So if you had a U.S. citizen brother or sister and you are from any country except these countries, you might have a quicker time. Now, it's all relatively speaking, because May of 2007 was not exactly yesterday. Every once in a while, I'll get a phone call, maybe 2 or 3 times a year. I'll get a phone call from someone who said, hey, way back, you know, in 2004, 2005, I'm a U.S. citizen. I filed for my brother who's back home in Nigeria, Canada, wherever. And now the priority date's current. Can we go through the next step of the process? And God love them. I mean, that's a horrendous delay and horrendous time to wait, but that's what we've got to deal with sometimes. Okay, so that's how the visa bulletin works for family-based, and based on brother or sister relationship. You pull your ticket, you file your I-130. The metaphor is like think of it like a deli. You pull your ticket, you wait for your number to get called. If you don't pull the ticket, no one's calling your number. So that's how that works in a simple example. Now let's go down to the employment-based categories. Employment-based, there's 5 employment-based preference categories: EB1, EB2, 3, 4, 5. Employment-based preference category 1, 2, 3, 4, 5. A lot of my clients who are high-skilled, high achievers will gravitate towards the EB1 category. The EB1 category is self-petitioned, so you're not relying on a U.S. citizen or green card holding family member. You're not relying on a job offer from a U.S. employer. We don't have to go through what's called the labor certification process or the perm process. Those are definitely things we have to worry about in EB2s and EB3s, where the employer tries to recruit someone, certifies their efforts with the US Department of Labor, certifies that they were not able to find a US citizen or green card holder qualified, and then are allowed to file not the I-130, but the I-140. So the I-140 is the employment-based version of the first document, pulling the ticket. For my EB1 clients, we just go directly to file the I-140. We don't have to worry about a labor certification. We don't have to worry about a job offer or an unwilling employer or a recruitment process. So that's one of the big benefits of the EB1. See here how there's a letter C next to most countries, all chargeability countries, and then a C next to Mexico and the Philippines. That means that the priority date is current. If someone was filing their I-140, they're taking their ticket, the I-140 gets approved, they can immediately go into the next step. There is no wait time where they're waiting for their priority date to become current. It already is current. But see how it's a little bit different for people from China and from India. For my Indian national clients, they're waiting several years. For my Chinese clients, they're waiting a few years, but not as bad. Now look to EB2 and EB3. For my Indian national clients especially, this is heartbreaking. Look here, the retrogression for EB2 and EB3 is retrogressed 12 years plus. And that is just heartbreaking for those people. For my Chinese clients, going for EB2 and EB3, a little less severe of a delay. But the point I'm making is the strategy is to identify the preference level category that we're looking for, identify what we're trying to accomplish, and then work backwards. So that if say, for instance, I have a Chinese national client who's just been awarded, say, an O1 visa or an H1B visa, we're planning ahead so that we're perhaps filing our I-140 well in advance of when perhaps a non-Chinese, non-Indian client would do the same. So that's what I wanted to cover this morning. There's been some changes to the fees. There's been changes to the visa bulletin. Every month there's a new visa bulletin. I just dropped the visa bulletin link into the chat. So click on that before we hang out so that you can get that. And like I said, I'll send you a link anyway. So I wanted to cover those topics. If you have any questions for me, let me know. Otherwise, I'm happy to schedule a time to chat one-on-one. These are complicated issues. These are uncertain times. Planning, preparation, persistence, they're all P words. That is the way to deal with the stress and uncertainty of even in normal times, the chaos of the immigration service, let alone the politically charged environment that we find ourselves in now. Thank you so much for attending today. I'll send a recording of this to everyone who's signed up. Have a great day.